President McMichael of OACT branch and everyone, hello. It's my great privilege to speak at the Australian Institute of International Affairs, and thank you for participating today. I'm especially honoured by Dr. McCosker being our discussant, and there is a lot to discuss, as you're all aware. These, of course, are my personal views, but I do enjoy very much these days the freedom of the bar after 47 years in the service. Many of you will know a lot more about these issues than I do, so please feel free to contribute heavily in our discussion. And by way of full disclosure, I was the last person that the Navy would entrust to navigation. So in calm seas, let alone a storm. And a few weeks ago, when Heath and I were talking about the topic, I suggested normative dissonance, and he said, how about the normative storm? And I think that was wonderfully prescient, if I could say, President. But let's remind ourselves on everyone's behalf of people facing the storm in Queensland and northern New South Wales as we speak. But anyway, time certainly brings change, and this is momentous and consequential, and we have to deal with it as best we can. I certainly did not imagine the consequences of a second Trump administration on international order. And as Professor John Blaxland recently put it, it's more unilateralist than isolationist. It is difficult to determine who is holding what hand of international order in cards, liberal through to autocratic or oligarchic, and who is partnering who. These are disturbing developments. For so many of us with either a professional or civic interest of concern as regards Australia and its place in the world, and that's Allen Gingell's wisdom and legacy, there is a need to recalibrate long-held perceptions and understandings in our strategic situational awareness as we navigate different times. There will be effects on the norms of international law-based order as power and authority and values. Three crucial elements in international law, on my understanding, seem to be realigning. And more about this as we go. As regards our topic of navigating the statecraft this evening, I would like to talk just broadly about a range of interlinked aspects and take a small diversion on the way. First, the concept of international norms generally, what I call a little theoretical broccoli, but some do like broccoli. Secondly, legal norms and international law-based order. And thirdly, and this is a little complex, the process of normative signalling and the paired phenomenon of the life cycle of legal norms. Signalling is very important in statecraft. International law is much more than static rules. It is a live-to-air process, especially right now. Legal norms exhibit the life cycle of norms like all norms. They can get born, or as we lawyers like to say, crystallize, sometimes mysteriously. They can prosper, come under stress or existential pressure, lose clarity, their determinacy or legitimacy, and possibly collapse. We'll briefly touch upon two contemporary issues. First, the use of aggressive force, and secondly, the application of the laws of armed conflict in extended campaigns. And ideally, we can see discussion on other areas, for example, the law of the sea, so topical recently, climate change, trade and tariff wars. So there are quite a few normative storm fronts. Finally, some brief observations I'll make about statecraft and the way ahead in such challenging times. Well, first on international norms. Some years ago, when I was a visiting fellow at the ANU Law School, I started looking at Australia as a middle power in international law. It was Professor Andrew Carr of the ANU Strategic and Defence Studies Centre who spiked my interest as regard what norms were about in international relations. I wondered how the same term could also be used without much professional introspection or theoretical angst in international law. What was this all about? And could the norms in international relations and international law be brought into some correlation or relationship? Not an original thought, I should say. What I read into, frankly late, was the social theory of international norms. Then I reviewed my preferred approach to international law to see if an interdisciplinary bridge was buildable. The preeminent normative theorists, Martha Thin-Moore and Catherine Sicking, describe norms as a standard of appropriate behaviour for actors with a given identity. More tangibly, perhaps, Tanisha Fazal, writing recently of the power of principles in foreign affairs, described international norms as guidelines that tell states which actions are and are not appropriate and provide metrics against which to judge others' conduct. So the key normative elements are identity, maybe superpower, middle power, or lesser powers, standards of appropriate behaviour, that is what is expected in a particular context, and metrics for judging standards of appropriate behaviours, and I would include a state self-judging its own behaviours in that reach of metrics. For my part, normative metrics fall along a political legal continuum, and much in international affairs is a mixed hybrid. I do think that norms in general operate in a shared interdisciplinary space between international law and international relations. I'd like to say that we're all normativists now, with various contributions to make in common cause. That said, the legal end of the normative continuum needs articulation. Arguably, the expected standards of appropriate behaviours, drawing legality and legal consequences, merit more explicit, exacting, and non-derogable normative metrics. And that is indeed the case with what are known as the peremptory norms of general international law. These include the prohibition of aggression, the prohibition of genocide, the prohibition of crimes against humanity, and the basic rules of international humanitarian law. These, inter alia, are the most fundamental peremptory norms, crystallising the lived experience of generations who suffered in the modern era the worst behaviours that humanity can engage in. It is the common experience of us all over the last several years especially, given just reasonable attention to world events in the media, capitals and international fora such as the General Assembly, the Security Council and the International Court of Justice, that these peremptory norms are under intense strain. These norms are the very foundation of international law-based order. Call it a normative storm. Corrosion of that foundation hazards the edifice so elaborately constructed in many functional subject areas of international law, for instance, the law of the sea, climate change, and international trade. In these areas, the normative metrics are less exacting, more based on agreed technical rules in many treaties especially, and system-enabling legal principles such as proportionality and equity. But these rules and principles are not insulated from top-down turbulence at large in the broader international law-based order, and we've seen signs of that for a while now, and it has become our daily fare. Secondly, let's consider international law-based order and statecraft. I mentioned earlier working on Australia as a middle power in international law. And my take was set down about a year ago in the form of a long paper, Australia and the International Law-Based Order and Statecraft in the Indo-Asia Pacific. The paper's on my New South Wales Bar website. Given the incredible events of the last week or so, and with fresh eyes, I asked myself in thinking about this evening whether I'd wrought a limited shelf life historical piece, but not entirely, I hope. Against the tide, the paper is pointedly set in the Indo-Asia Pacific rather than the orthodox Indo-Pacific. I maintain, perhaps too simplistically, that geography is destiny. Opinions will differ on this, of course. International law is a seamless global web. Developments in Europe and America and at the United Nations and in the International Court of Justice are legally consequential globally. But the Indo-Asia Pacific, its lands, nations and oceans is where we are, and we have our own concerns demanding astute and adroit navigation through our statecraft. I looked at the jurisprudential nature of the international law-based order. It has an historical lineage, as you may well know, of about 400 years going back to Westphalia, long since not on the map in Europe. The elemental concept of nation states is the creation of international law. From that emanate all the relationships we hold, study and analyse in international relations and order. Preference Preferencing the international law-based order over the rules-based order is about understanding international law as both a dynamic and influenceable normative process and a store of established rules and principles. The confluence of intense expectations amongst the governments or elites of nation states of lawful authority and legitimate power. This is what it's about. These intense expectations are articulated as the appropriate and required standards of behaviour in a particular context. Now, I absorbed this approach to international law from Dame Rosalind Higgins at the LSE, and she was, of course, one-time president of the International Court of Justice. Diplomacy and discourse coming from the direction of the rules-based order lacks agency for statecraft. It is platitudinous, in my view, in the face of real and legitimate power and conjoined authority. It is too passive to shaping inevitable change, and I still hold that view. We might talk about the PLA Navy's transit down under in discussion, but for now I note that the Defence Minister, often previously referring to the rules-based order, shaped his remarks concerning the PLAN's activities as, quote, international law has to be our touchstone. Now, note China's Foreign Minister Wang's remarks at the recent Munich Security Conference, where we recall the long-building geostrategic storm broke and the dam burst. Fascinating remarks. Let me quote, "It is important to respect international rule of law. As an old Chinese saying goes, circle and squares cannot be drawn without compasses and rulers, which means nothing can be accomplished without following norms and standards. The purposes and principles of the UN Charter provide fundamental guidance for handling international relations. They are also an important cornerstone of a multipolar world. The world today is witnessing incessant chaos and confusion, and one important reason is that some countries believe might makes right and have opened a Pandora's box marked the law of the jungle. In reality, all countries, regardless of size and strength, are stakeholders in the international rule of law. The multipolar paradigm must not be a state of disarray. Without norms and standards, one may be at the table yesterday, but end up on the menu tomorrow. Major countries must take the lead in honouring their words and upholding the rule of law, and must not say one thing and do another or engage in a zero-sum game." Now, about normative signalling, which I mentioned we would get to. Foreign Minister Wang's observations are designedly assuring a discourse of course, and with a clear and real end message. This is what may be called normative signalling, a primary tool in the inventory of statecraft. I first heard the phrase, the strength of normative signalling, used by the late and brilliant Australian Judge James Crawford of the International Court of Justice. And of course, Judge Hilary Charlesworth is now on the court. Anyway, the phrase stuck with me, normative signalling, as a way of describing international law-based order, which can be nebulous to comprehend as it lacks all the traditional elements of domestic legal system we're familiar with: parliaments, legislation, law enforcement, compulsory courts and tribunals. They're hard to find in the international law-based system. I say the process of international law-based order to impart the reality that it's about rules which imply established and quite specific norms, but also it's a dynamic and changing phenomenon. And understanding this reality is crucial, especially when there is uncertainty or instability, and in devising normative strategies within statecraft, as you might prefer the status quo or you seek to change the order in a particular direction. Statecraft can engage at the top order, meta-norm, if you like, of the obligation to comply with the overall norms of international law-based order, and it also engages at regime-specific level, like international trade. So you have a bifocalized approach. All nation states inherently each carry lawful authority simply by being nation states. It comes with club membership of the international community. It is a horizontally dispersed legal order. With all states being nominally at least sovereign and equal, a normative signal in international law is the strength of the combined pulse of lawful authority and controlling power. That normative signalling occurs in many available fora and channels, from capitals and diplomatic channels, in international institutions, at conferences and conventions. To reiterate, normative signaling is communicating about expectations of appropriate and required behaviours. It's about standards to be met and perspectives of others' behaviours. It communicates what values are in play. It communicates what power resources, hard, soft, smart, economic, or dare I say, dumb, it can be your own choice, might be deployed lawfully or otherwise to gain normative compliance. And not to overlook the normative signal pulsed by a formal abstention and a yes-no vote in highly authoritative fora, which effectively parks a state's agency for their own wide variety of strategic reasons. And that is a phenomenon that's starting to happen. It is a competitive process and at times vigorously competed. Normative signalling can be exercised individually or a combination. So Q, as we have the coalition of the willing, revived just this week. There can also be opposing combinations competing more or less openly for normative change or desuetude. There are no predestined, inherently moral or permanent outcomes. They are a matter of agency and decision and effort. So let's quickly look at the Russian aggression against Ukraine, which is an excellent contemporary demonstration of all that I've been talking about. And there is some cause for concern about normative erosion in the peremptory norm of the prohibition of aggression. Many states individually and collectively committed in support of the lawful defence of Ukraine, and they have lawful standing to do so, and by doing so they have exerted, at least for the last 3 years, sufficient controlling power to support their perception of the norm against the aggressive use of force. Of course, what comes next is of monumental significance, and just to observe that the power and authority of the United States in the normative balance is prodigious and consequential. If the United States fully deploys a more isolationist worldview, the erosion of the norm prohibiting the aggressive use of force might well further accelerate. I say further accelerate because of perhaps pre-programmed sequence of events preceding the White House encounter last week between the presidents of the United States and Ukraine. If pressed to argue the case that we are in a normative storm, I might first reprise the recent Munich Security Conference in mid-February. It seems such a long way back, I think you might agree. A dark cloud gathered over the explicit mutual defence obligations under the legally binding Article 5 of the NATO Treaty of 1949. But note that President Trump later answered a pointed question in his White House press conference with Prime Minister Starmer that he supported Article 5. One of the normative bedrock principles of international law of treaties is that under Article 26, legal obligations will be performed in good faith. Of course, a state can contract both in and out of its treaty obligations. Notably, if the state wants out of NATO, it simply needs to give a year's notice to the depository state, which happens to be the United States. Asking President Trump about his support for NATO Article 5, it was a legitimate question from the press corps, but that it was so evidences more of the storm. However, on the other side of the ledger, it is noteworthy that under Article 3 of the NATO Treaty, NATO members are obliged separately and jointly by means of continuous self-help and mutual aid to maintain and develop their individual and collective capacity to resist armed attack. I've not noticed this provision being pushed in the controversy about mutual defence obligations in NATO. And on the fly, here's the thing. Noting current talk about Australia's level of defence spending, there is a similar provision, I think, in Article 2 of the ANZUS Treaty. That said, for me, Alan Bean, during the first Trump administration, fairly convincingly argued that ANZUS was an historical artefact. Opinions might differ on this, of course. But back to Ukraine, we had the General Assembly resolution in emergency session citing the full-scale unlawful invasion of Iraq by the Russian Federation. What was extraordinary was that there's a pronounced drift in the General Assembly over the 3 long years of the war towards abstention about the aggression against Ukraine. In 2022, there were 141 states in favour, 5 against and 35 abstentions. This year, was down to 93 in favour, 18 against and 65 abstentions. Then came the encounter at the last week in the White House, which we all saw, and that is obviously ongoing with the letter from President Zelensky, and the rare earths deal may be revived. But here's a diversion slightly out of lane, but relevant, I think. In the capitals the world over, especially in Europe, as we saw, there is a serious and basic normative calculus about how things are changing. In a ruthlessly transactional order, are deals really deals, howsoever they are settled, be they informal legal binding treaties or agreed in the shadowlands of the vast edifice of formal and informal, non-legally binding agreements and memoranda, settled under the hand of either heads of government, ministers and secretaries, or empowered diplomats and officials, serving during particular administrations and governments of the day. There is a vast store of these documents. Australia's defence and national security arrangements are in both formal treaties, ANZUS 1951, and the AUKUS tripartite agreement for naval nuclear propulsion of 2024, which has substantive obligations. It's obviously costly, and interestingly, its expiry date is 2075. Many non-legally binding documents, which nonetheless are settled with great care and legal exactitude by officials and representatives of the respective parties on intelligence sharing, joint facilities, and also basic agreements are in place. Arrestingly, recall that President Trump asked for clarification when questioned about AUKUS, and maybe he's been apprised since. But the courtesies and modus vivendi of international comity amongst close allies, a form of soft law, if you will, which screws the linkages of more formal international law, could well be destabilised by much closer top-down, perhaps autocratic monitoring. It's odd to say that in reference to America. This could render officials and key interlocutors less flexible and willing to exercise the judgment traditionally exhibited by both apolitical and politically appointed career officials to craft or interpret agreements, formal treaties, and a vast web of the less formal non-treaty agreements alike. Information sharing could be eroded. The field might well become more transactional. And I think we need to consider that kind of possible fallout going forward. Just to round off, the second particular normative storm that I'd like to briefly take in is erosion and indeterminacy in the laws of armed conflict. As an international lawyer and a member of the independent bar, I profess a deep commitment with my many like-minded colleagues to protect and advance the values of human decency and dignity. The laws of armed conflict of peremptory normative status stand as a protection of last resort of those values. We are all aware of the immense effects on civilians and non-combatants in many theatres of conflict, state against state, internal armed conflicts, or mixed and highly complex situations. This is a tragic catastrophe in human suffering and displacement. It is potentially exposing doctrinal indeterminacy and normative coalescence of the long-standing bifurcation in international law of the jus ad bellum, governing the resort to armed conflict, primarily in self-defence under Article 51 of the Charter, and jus in bello, which regulates the conduct of armed conflict, whatever its justification or pretext under international humanitarian law. The inherent right to lawful self-defence is both a gateway provision and a continuing prescription to be satisfied for as long as force is used in legitimate self-defence. Classically is predicated on the necessity to use force, including anticipatory force, being instant, overwhelming, and leaving no choice of means and no moment for deliberation. The act justified by the necessity of self-defence must be limited by that necessity and clearly within it. This goes to proportionality as regards the scale and type of forceful means in response to the initial injury inflicted so as to achieve legitimate purposes of immediate and preventive security. A sustained campaign grounded in legitimate self-defence is not a box to be checked only ab initio, regardless of the changing context that justifies the initial claim. with residual emphasis then shifting to the actual application of force almost exclusively to purported compliance with international humanitarian law in its prescriptions on military necessity, proportionality, and humanity. There are thus two types of proportionality under two distinct sets of norms: in self-defense and under the Hague and Geneva laws in taking precautions in conducting an actual attack. Conflict, there's a clear danger that these distinct sets of norms, in my view, are being conflated because of the common term of proportionality and rendered indeterminate within this most crucial set of normative prescriptions. Anyway, the way ahead towards fashioning Australia's statecraft in the highly complex and dynamic normative situation we're now in, as against, say, a year ago, I wonder whether there is a need for a substantial recalibration of the 10 normative personas I previously sketched out, with an eye to Australia's agency and identity as an independent sovereign state, respected globally and regionally. I don't think so, but I would, on reflection, elevate protection of our national defence and security to the top of my list. It was number 3 before. How we deport ourselves and our alliances going forward is crucial. Relatedly, also our multilateral persona is, of course, very important, especially within international institutions, and it is highly sophisticated. Our commitment to humanity in warfare and direct national accountability for compliance with the laws governing the resort to force and its lawful application is essential in contributing to our commitment to the international law-based order. And we need to continue within our considerable means to contribute vigorously towards getting control of the environment for our planet. There's much else to our agency and identity in our statecraft in international law-based order, but that surely is enough now for me. But one last feel-good thought. One of my favourite symphonies is Beethoven's 6th, the Pastoral. You may know it. It has 5 movements. The first 3 movements are noted as cheerfulness and the pleasures of being in the country. The 4th is the storm. The final movement is notated cheerful and thankful feelings after the storm. Thank you.
Well, good evening, everyone, and thank you, Heath, for the introduction. Thank you, Michael, for your presentation, and ladies and gentlemen, distinguished guests, and a particularly warm welcome to the members of our diplomatic community. Gosh, Michael, there's a lot to unpack. You have covered a lot of ground this evening, and I am glad that you've ended on a reassuring note, reminding us that there is the prospect of more cheerful times ahead. Though, of course, we are currently in the thick of it. In the thick of multiple storms, and in all likelihood, there's going to be an extended period of hunkering down before these challenges will ease. These are deeply turbulent times in geopolitics, and particularly for those of us who are working at the interface of international law, diplomacy, and international relations, very dispiriting. And for me, working to support both the Australian government and a range of other clients across the Asia-Pacific region, it's been a very unsettling time observing these very striking assaults on the international law-based order, not just recently, but over a number of years. So what I wanted to do was to draw out some key themes, both of Michael's presentation, as we've just heard it, but also of his extended written paper, which is the subject that informs his presentation tonight. And then I'll add some observations of my own based on my experience as an international law practitioner, but of course speaking in my personal capacity this evening. And then we'll open up to questions. So for me, a core question arising out of your presentation, Michael, is a very practical one. How can we ensure, excuse me, that our tools of statecraft are adequate to help us navigate the normative storms that are facing the international law-based order? And how can we strengthen these tools? And as Michael has said, this toolbox of statecraft is a hybrid one, comprising legal, diplomacy, and policy tools that need to be used together skillfully. As an international lawyer, particularly one working for government, a lot of my daily work involves operating at the interface of law, international relations, and diplomacy. International lawyers always provide legal support in a policy context, working closely with our policy colleagues. And my work is also informed by a long-standing interest in these intersections of law and diplomacy. This was the topic of my PhD now some years ago, in which I was looking at the strategic roles that international law plays particularly in dispute settlement. And a lot of my work over the last 10 years, particularly my work with the International Committee of the Red Cross, has focused on promoting compliance and accountability, particularly with international humanitarian law, and looking specifically at what are the practical measures of statecraft that are available to promote greater compliance with IHL, and what are the measures that we can use to try to influence positively the conduct of other actors to change their behaviour. And as Michael has indicated, I mean, this is more important than ever before. In 2025, there's currently over 120 conflicts around the world. The ICRC has expressed grave concerns that international law compliance seems to be going backwards. Of course, much attention is focused on Ukraine and the Middle East, but these are challenges affecting all geographic regions. The terrible conflict in Sudan is just but one example. So this has led Australia and other like-minded states to call for a renewed focus on IHL accountability, going back to basics, going back to the fundamentals, with many different initiatives in pursuit of this goal. Just one initiative is the proposed declaration on the protection of the rights of humanitarian personnel. But many of these initiatives, in my view, have a common denominator, which is linked, I think, to a central question prompted by Michael's presentation, which is how do we use the tools of statecraft at our disposal to more effectively influence the behaviour of other states? And this question is also an important theme of the Defence Strategic Review, which, as many of you know, has a strong focus on statecraft. It discusses how we deploy all elements of national power in statecraft, seeking to shape a region that's open, stable and prosperous, predictable, operating by agreed rules, standards and laws. So, as Michael has noted, the international law-based order comprises intersecting normative systems. Of course, the normative system created by the rules and principles of international law, but also the much older and longer standing principles and customs of diplomacy. And for me, the task of upholding the international law-based order really requires upholding both of those normative systems because they're interdependent. And I tend to think about this in terms of very practical skill sets, because these are not just normative systems, they are professional communities, fields of professional expertise requiring specialist tradecraft, skills and techniques that need to be learned, and tools and techniques that need to be used in combination with each other, as we were saying before. In my view, it's this interdependence of law and diplomacy that's one of the key reasons why the televised episode in the Oval Office was so shocking, because it made the threats to core tenets of our international law-based order sickeningly clear. We saw disregard for international law, disregard for and misrepresentation of facts, truth, and also serious disdain for customary practices of diplomacy and civility for interstate communication. So, thinking about this interdependence of the diplomatic and legal normative systems, there are three key features of Michael's paper that I think are particularly notable, and I just wanted to draw out. First, the way that he's put this issue in historical context. And I think, Michael, your presentation can be situated in a really rich body of thinking, particularly over the last 10 to 15 years on the rules-based order. And some of the themes in your presentation draw to mind, for example, the excellent 2021 AIAA publication on Australia and the rules-based international order, edited by Melissa Conley-Tyler, Bryce Wakefield, and others, in the late Alan Gingell. I'll come to this other publication in a moment, but also the Lowy Institute's project, of course, on Australia's security and the rules-based order, an excellent publication that's been tracking the evolution of this concept, the rules-based order. I do share, Michael, your preference for the phrase international law-based order, and I know there's a lot of discussion about rules-based versus international law-based. I think for the purposes of our focus this evening, though, those differences are less significant for me than what are we going to do about the threats to both the rules-based and the international law order. So I think that my first point is that these storms are not new. They've been brewing for some time, and there's a rich body of thinking on these topics, I think, of which Michael's presentation is a continuation. The second feature of Michael's paper, which I'm sure some of you haven't yet had the opportunity to read, but you'll be pleased to know, is that his reassuring projection is that despite the challenges, the international law-based order will endure, but in a changed form. So that picks up on that positive note about the cheerful times to come after the storm. So you have reassured us in your paper, and I'll hold you to it, that the future will not be a normative anarchy, but you have said that we are going to see evolved designs of multipolarity and hegemonic spheres of influence. So this is clearly an acknowledgement that we are going to see geopolitical power changes, different configurations of power in the future, and we can see this happening and playing out in our region. The third feature of Michael's paper that I wanted to highlight, and you've touched on this idea of personas in your presentation, but I would commend this particular part of Michael's paper to everyone because it's very interesting. For me, this was a standout part of your written paper, but essentially he articulates 10 personas or 10 identities for Australia in the international law-based order. And just to give you a flavour, I won't list them all, but some of these identities are Australia as a constructive, good faith multilateralist, plurilateralist and bilateralist, Australia as a confident and assertive regional and global champion of rules, norms and principles, Australia as a responsible steward and custodian of the lands and oceans of the global and solar commons. And just one last one I'll mention is Australia as a nation of immigrants, lawfully and humanely protective of its borders. So the full list is worth reading, but this is interesting because Michael argues that when you look at all of those 10 different identities which overlap, they aggregate the most important dimensions of middle power agency. And so I read that as summarising essential features of Australia's current identity and practice that we need to uphold and strengthen ourselves in order to be able to model good behaviour as a good international citizen in the region and beyond, and contribute positively to the international law-based order. So where I think it would be interesting to push the discussion further is to ask, well, how could these 10 points help serve as a really practical guide for our statecraft, or a yardstick against which to measure how well we're tracking? So as we look forward, I mean, we are clearly in a time where sophisticated diplomatic and legal statecraft skills are needed more than ever, but where there has been an acknowledgement that Australia's skills have experienced some degradation over recent years. This is not only my personal view, but it was acknowledged in the Defence Strategic Review, where it states that there needs to be a reversal of a long-term reduction in diplomatic resources and increasing our diplomatic proficiency make sure it's resourced, directed and focused. And these are, of course, not just challenges for countries like Australia, but for many others as well. But as an international law practitioner who's very pragmatic, I'm always thinking about what does that translate into in concrete terms? And some of the concrete things I suggest that strengthening statecraft in these areas could involve would be things like more training for diplomats and government legal advisors at all levels, greater valuing of specialist skills in addition to general skills, measures to promote more stability and less frequent turnover of staff within government departments so as to enable time for junior officers to actually grow and gain experience before they move on. And also an effort to really strengthen our core technical skills in bilateral and multilateral diplomacy, the art of persuasion, the art of effective communication in bilateral and multilateral settings, how to engage in complex multilateral meetings, what to do in the margins of those meetings. Now, there are in this room some of Australia's most experienced former diplomats, and we also have very experienced diplomats who are currently serving. So you might be rather surprised by my suggesting that we just need to go and redouble our efforts in training on the fundamentals. You might think for these things these skill sets are kind of second nature. Aren't these things just part and parcel of the training that is received? But from my observation, there is less training and less experience and proficiency in some of these skill sets than there used to be. So I think this is an area that could readily be strengthened with simply more prioritization and allocation of resources. And I know there are efforts already being made to do this. If I might also say, we do need to train our lawyers and our policymakers to work together differently. We need our lawyers to better understand the policy settings and our policy officers to be trained to have the mindset that consulting with lawyers is crucial, that law is a helpful strategic tool rather than seeing something as law that gets in the way. Well, the lawyers will slow things down, make things more difficult. Speaking from experience. So, I mean, if we can strengthen and sharpen Australia's own hybrid diplomatic legal statecraft capacities, that will not only stand us in better stead to weather these current normative storms, but it will enhance our ability to engage in more effective capacity building with neighbours across the region. So in conclusion then, before we open for discussion, we have Cyclone Alfred bearing down on Australia at the moment, and this requires us to assess the likely trajectory of the storm, to brace for serious impacts, to prepare, to plan, to come together across and coordinate across different communities to best position ourselves to weather the consequences. And this too, I would suggest, needs to be the approach as we navigate the series of complex normative storms that Michael has outlined. We need to carefully assess, prepare, plan, coordinate across different professional communities to do our best to support and uphold the architecture of the international law-based order to ensure that it is resilient, and to use all the available tools of statecraft to do so. And as we look to strengthen those statecraft skills, I'd suggest that in particular, Michael's 10 personas would serve as a very useful guide to carry with us. So with that, I'll conclude my observations and I will open the floor for questions. And I know Heath will have some questions from the room and possibly some questions online as well, but maybe we'll start with questions in the room. And yes, up the back. And if people could stand and also identify, if possible, and identify yourself, that would be terrific.
Thank you. My question relates to regional customary law, which I haven't heard about for a long time, but noting that the focus of international law and national norms, seemingly as conveyed this evening, seems to have been more at that macro level. And there was a reference to resourcing statecraft. Is there any potential scope for revisiting potential regional customary law if we were to want to try to get bang for buck, or is the world simply too small now for that to be worthwhile?
Thank you for that question. Just while I'm leaving Michael to think about that, and I've got some thoughts as well, we might take a couple of questions. Yes, please.
On Australia, had a lot of national affairs and public services. Just leaving some of the things you've suggested are very interesting, but in one way they're longer term. They're more immediate things. Australia could be doing in the shorter term, given the storm we're about to enter. Do we wait for things to settle down in the United States, but perhaps some difference of leadership there? What are there things, more practical things we could do Australia with in concert, multilaterally, regionally, or with bilaterally to try and protect that international law-based order, which is under such attack at the moment?
Thank you very much. Well, we might take those two questions and respond. Michael, would you like to respond to either or both of them?
On the first one, regional custody, well, that's a really interesting point. If you think of resources protection in the Pacific, especially, we have a massive ongoing defence program to support that. One of the things that can happen is that the particular, say, fisheries and use of economic zones and other things can develop their own regional practice, which, to be effective, needs to be enforced. And I think that's certainly an alive prospect. On the more question of more immediate things, and I note earlier what Sarah was saying about people preparing people for the statecraft. I think that really pertains to preparing some of our best people in defence who are just so natural in the diplomatic arena. But I think we need to be immediately concerned about the impact of America pulling resources or interest or influence in the Pacific, and I would say move quickly and leave no space to fill in gaps or needs, because if that's not done, it's very obvious that there are other contenders who are very well resourced and will move quickly.
Thank you, Michael. And if I might just add a couple of quick things in response as well. I think regional custom, like customary international law generally, is notoriously difficult to establish because one has to prove that there's sufficient state practice and opinio juris. So the sense that one is engaging in that practice out of a sense of obligation, other than just engaging in that practice for other reasons. So I am not confident that it will be very easy to establish or to make arguments that regional custom is emerging. And on the issue of what actions can be taken, I suppose I would just add that I think Australia is very vigorously taking a number of actions, but many of those actions would be behind the scenes and not necessarily in the public eye. But I think some of the things that are more visible are Australia, for example, is continuing to work with like-minded states to find other ways of contributing, for example, in relation to supporting Ukraine, but also through the aid and the capacity building that we're doing across different sectors, also the intensive diplomacy in key UN hubs in Geneva and New York. So I think I would just observe that there are many, many things that are happening on many fronts, but a lot of them not necessarily visible. Yes, Matthew, a question.
Matthew, 1 minute while we get my, sorry, yeah. My voice is fairly loud, but Matthew Newhouse, ANU, delighted to be, I'll take it a little way, delighted to be here and to hear from both of you on this. This, of course, as you know, is a particular specialty of mine, and I think Trump takes it to a whole new level. Of course, in the past, Australia has had issues with American presidents. I remember when John Howard had to stand up to pressure from George Bush that we don't ratify the Rome Statute and join the International Criminal Court, and he did so. And even during my own time before going to The Hague, when I was heading the Middle East and Africa division, actually I'd got to The Hague by the time this became a big issue, but I was leading our representation at a conference when Trump tried to basically betray the Kurds, who had been absolutely essential fighters in the fight against ISIL in Iraq, just on the verge of the victory in Mosul. Fortunately, we worked with allies to push back. And people in the system actually were very grateful to allied countries like Australia and the UK and others who did so. My question to you particularly, Sarah, is in the current environment, and perhaps after the first couple of months of storms, we have some very professional United States diplomats, international lawyers, and so forth. Do you see the opportunity of working with allies, with those in the system, to make a difference?
Thank you, Matthew. I mean, I think the short answer is yes, and also we must find every way of working with our counterparts to navigate ways forward. I think we're in an interesting situation because a country that for so long we have, I mean, the phrase like-minded is thrown around a lot, but all of a sudden we have a hitherto like-minded state that's not so like-minded, at least in some of its public projections. But of course, states are not black boxes, and that there are many individuals, legal and policy experts and diplomats, if they haven't been fired, walked out of the building, who are still there. And so we must, I think, we are in a period where our diplomacy is going to need to be more sophisticated. We will have to redouble our efforts, reach out to networks, seek to be sophisticated in the way that we cultivate relationships, gather information in this environment where there's a lot of misinformation and disinformation. So I think the short answer is I think our diplomacy is going to need to be multi-level and more variegated perhaps than it has been. You're right. I mean, this is not one new set of circumstances. It's and we can think about this in relation to the US, but this is a common thing that, again, for the many highly experienced diplomats in the room, it's not an unusual situation to be faced with an interlocutor who is difficult. But it's there that we need to be ever more creative in our diplomacy. And I did want to, just on your point about that moment in time about the ICC, Michael and I were just talking about this actually beforehand because you were there at that time. I wonder if you wanted to say a couple of things about that interesting moment in history.
Matthew, he may not remember me. We did decide in the end with the cabinet to sign on to the ICC. There was an afternoon when I was sent for and took one of my best officers who knew more than I did over to the Prime Minister. And we sat with him, as Heath and I are now, and he said, should we be signing this convention? And we said, if it was not to be signed, you should have been told a lot longer, Prime Minister, than before now. You might recall that he had issues in his cabinet, and he checked, I think I'm able to say, with Henry Burmester, the great General Counsel, and that evening it was decided that we would go with the ICC. So that's how it worked. I don't think I'm breaching anything in saying that. Can I just add as well that some of my happiest work is being done with certainly US and British service lawyers. They're wonderfully trained and very, very capable people. And I certainly hope that continues the case, especially out in the Pacific at the the big Pacific headquarters where we do interact a great deal. We developed the rules of engagement system that Australia has now on the basis of very close contact with our allied lawyers in 1990 after the first Gulf War. We did not have a rules of engagement system, and we were able to get great assistance in putting it together. And I hope there's not a reticence that creeps into those relationships, which are long standing.
Thank you. And Heath, I imagine we might have some questions from online.
Yes, we may have time for one question online, and it comes from Emily Morris, who's asking, what role do you believe the increased spending in defence plays on Australia's position and responsibilities in the region, diplomatically and otherwise? So maybe Sarah could start with that.
I will tread carefully because I currently provide some legal support to defence. I would say this was acknowledged in the Defence Strategic Review that there needs to be increased resources given across a whole wide spectrum of defence activity in the Pacific, not just in enhancing our military preparedness, but also in terms of supporting our cooperation across things like defence science and technology, our capacity building with other nations, our exercises and operations. So I think when we think about increased defence spending, there's a pretty heavy cooperative element to that. I don't think it's purely about enhancing Australia's military capabilities. There are many facets to that, but deferring to Michael's greater length of time in the defence world. Michael, did you want to add anything?
Professor Dibb, I noted the other day was saying that if we raise defence spending, certainly up near what is talked about today, I think 3% or beyond, will be hugely impactful, and which I was really surprised to hear coming from him, and he was, I think, fair to say, reticent about how that could be achieved, but there appear to be pressures coming our way that we need to spend more, and there's talk that this coming election we're about all to go through will feature quite prominently defence and defence spending. Some of you may have noted this morning's Australia Institute poll in the news that Australians are increasingly wishing for an independent Australian defence policy, and the level of support in that direction is climbing. So I think the next 3 months, probably, this is going to be a very significant issue. But what programs you would take the sorts of money from, given already our huge expense if we face with AUKUS, is going to be very hard to do. I know in defence, from my time in the Chief of Navy's office and the Vice Chief's office, those budget battles, even within defence, are legendary. So across agencies and across the whole of government, it will be very, very difficult.
Ladies and gentlemen, I think we might leave it there. I think it's a fair comment to say that there's no storm cloud without a silver lining. And tonight, our silver lining has been 2 excellent presentations by 2 very experienced experts in the field of international humanitarian law, who've been able to mix both a high level of theory with very long experience in practice. And for that, we thank you.